Chairman Willard, the stuff about New Hampshire on there is dated.
Is
So
it? Okay.
I need to update that. So,
No problem. I am on. Good afternoon to everyone. Let me welcome you to the Judiciary Committee meeting for the House of Representatives. We've got a list of several bills, but first I wanted to take a moment and introduce to you Bert Gall. Bert is with the Institute for Justice, which is a Washington institute, a think tank, I believe would be the appropriate classification, and Mr. Gall is here to speak with us as a committee regarding some of the issues that are facing us this session, addressing the eminent domain issues. So what we're going to do is allow about 20 minutes initially for that purpose. Mr. Gall, if you would give us some background information, your involvement with eminent domain. I think you were specifically involved with the Kelo decision, your institute was. So tell us some of the things you've been involved with.
Thank you, Chairman Willard, and thank you to the members of this committee for allowing me to speak to you today. I appreciate that. My name is Bert Gall. I'm an attorney with the Institute for Justice. I got to D.C. by way of Griffin, Georgia. That's where I grew up, and so I'm glad to be back in my home state to talk about this very important issue. The Institute for Justice and I were involved, very much involved, in the Kelo versus City of New London case. In fact, my colleagues and I represented Suzette Kelo before the United States Supreme Court, and we're still fighting every step of the way to make sure that she can keep on to the home that is rightfully hers, and the same is true for her neighbors. So I've helped to litigate that case and litigated a number of eminent domain abuse cases across the country. And when I say abuse, what I mean is the taking of someone's home or business for private commercial development. I think before the Kelo decision came out, most everyone understood the term public use in the U.S. Constitution to mean, a taking for something like a bridge or a road or a school or a courthouse. After Kelo, people have been kind of woken up to the notion that all throughout the country, eminent domain is often used for private development projects, for private uses. In fact, in one 5-year period, we documented over 10,000 instances where eminent domain was used on behalf of, for the benefit, or threatened to be used for the benefit of private parties. And Kelo has really brought that into focus. And obviously, in the aftermath of the Kelo decision, the reaction to that has been nothing short of phenomenal. I think you see the opinion polls as they've come out. You see 90%, 95%. People cannot believe that in this closely divided decision, the Supreme Court said, and this was their holding, that basically that any property can be taken as long as the government believes that more money or more jobs can be generated with that piece of property. So this has obviously caused a lot of outrage across the country. Indeed, you're not the only ones considering eminent domain reform legislation. There are at least 39 other states that are considering this same issue. And I wanted to talk with you today specifically about Georgia's vulnerability to private commercial development takings. And Georgia home and business owners are indeed very vulnerable. And the way they're vulnerable is basically through the redevelopment laws of the state, which are very, very broad. Those laws allow the taking of so-called blighted areas of land. And indeed, before Kelo came out, the way that most municipalities across the country took land for private development was through redevelopment. And still will be after Kelo, redevelopment statutes. Georgia's redevelopment statutes and definitions of blight and slum include things such as diversity of ownership, age, obsolescence, faulty lot layout. Those terms, I think you can find any halfway competent lawyer in the state could declare any neighborhood in the state of Georgia slum or blighted with those particular terms, and therefore allow what happened in Kelo to happen here. For example, just to illustrate a case I litigated in Ohio before the Ohio Supreme Court, diversity of ownership was given as a blighting characteristic. That literally means people own their own homes and businesses as opposed to one person owning all of them. Age. So if your home is 30 years old, 40 years old, slum or blight. Obsolescence, that's a term that has been stretched in one case that I was involved with, where homes were defined as blighted simply because they didn't have two-car garages, two full bathrooms, or three full bedrooms. And these are not just isolated, outrageous cases. These are how redevelopment statutes are typically applied for the accomplishment of private use takings. So obviously something has gone wrong here. The conception of the Fifth Amendment really, before Kelo and before the 50s, when the definition really started getting broadened by the courts, were traditional public uses. And those uses included things, once again, like a bridge or a road or a courthouse or a school. Also included would be like common carriers or public utilities, things that are heavily publicly regulated or certainly accountable to the public in a real way. And so real reform needs to move back toward those particular boundaries, because leaving it open as it is right now creates a really perverse incentive for communities to condemn entire neighborhoods, as you saw in Kelo, and so that they can generate more tax dollars. And what you often see across the country is that this process, eminent domain, a very public process, becomes very, very privately driven, where a developer or someone will step in and say, "I'd like this piece of property. Let's take a look at it. Can we commission a blight study to, quote, see if it's blighted? If it is, we will condemn." Oftentimes, you find, of course, that the developers are paying for the blight studies. They're paying for all the legal cost in a couple of cases that I have litigated. So I've given a handout to you today about 5 keys to strong eminent domain reform in Georgia. It's a little bit of an abbreviated version of what appears at the back of the white paper on Kelo that I've circulated to you. But what the main thing is to remove statutory authorizations, and also, I should add, constitutional authorizations for eminent domain for private commercial development. Forbidding that, putting restrictions on who can actually own condemned property once that occurs, prohibiting ownership or control, because sometimes you will see that property will be condemned by the government and then leased for like $1 a year. In fact, that was what was going to happen in New London. There was going to be a long lease of the property to the developer there. Make sure that whatever reform applies to all political entities, not just the state. It typically is going to be municipalities and other redevelopment authorities that are using the power. And certainly, if there are 2 main important points to stress, the first is that Georgia does need, in addition to statutory reform, constitutional reform. Simply because the Georgia Constitution, unlike most constitutions out there, specifically authorizes private use takings when the purpose is redevelopment. I'm trying to think of any other state that has that, and I can't think of it right now, but that leaves Georgia particularly open to these kinds of takings. And I know that there are a number of constitutional amendment bills that are being proposed right now. I've talked about a couple of those in my written testimony, but that should really accompany real statutory reform. The second point that is very important to emphasize is the last one that I've got here on this handout, which is don't let blight, and I put that in scare quotes, be the loophole that renders reform meaningless. Because condemnations are going to continue for generating more tax dollars. They're going to continue under the guise of condemning for slum and blight areas. I mean, that's the roadmap that has existed before, and that's the way it's going to continue. To simply say, for example, we're not going to allow condemnations for economic development, but we're still going to allow condemnations for blight, and leaving a wide open definition of blight basically means you're still allowing condemnations for economic development, since it's so easy to condemn under that standard. The strongest defense you can provide against the abuse of blight designations is to do something and this is an approach that Utah took back in 2004. they simply removed condemnation authorization from all redevelopment authorities in the state. That's an approach. They didn't have to worry about defining blight because they were simply removing that authorization, recognizing that there are regulatory processes available to deal with dangerous properties, and the police power that municipalities have always had. If you eliminate condemnations for redevelopment, there's still condemnation authority that exists as part of the police power for properties that are truly, truly dangerous. I mean, if we're talking about a property that catches on fire every week, or that is a real public nuisance or attractive nuisance, that is something that can happen, on a parcel, by parcel basis. You wouldn't be affecting that, even if you removed condemnation authorization, completely from redevelopment authorities for the purpose of redevelopment. So that's very important to keep in mind, because we've seen legislation that's been passed in a number of states. A lot of states, obviously, like Georgia, are just now coming back into session. But Texas and Alabama passed legislation almost right off the bat, off of Kelo. Alabama, I think, was indeed the first. But they realize that they have to go back and fix what they have done because they left open blight. And their definition of blight is much like Georgia's. It's very wide open. So an approach like Utah has taken is the strongest approach, and Georgia could indeed serve as a model. And Georgia would have the strongest eminent domain reform legislation in the country, a very early start, if it were to take this. If you are going to open up the Pandora's box of blight and say we're still going to allow that to happen, and that should be thought of as a fallback position, because what you find is blight is in the eye of the beholder, and different interest groups always want to make sure that their definition of blight gets in there so they can continue to take what they've always taken. You should at least make sure that blight means something that is causing an immediate and objective and concrete harm to individuals, to the public safety. Terms like obsolescence, terms like age, terms like diversity of ownership, terms like faulty lot layout, which can mean your yard's too small, according to some bureaucrat. I've seen it defined that way. Those are all back doors that can be used by developers and by condemning authorities to get around anything that you do. So, like I said, with blight, best thing to do is remove that authorization and recognize that their regulatory process preserve the police power, or then at the very least to define it narrowly. I don't want to spend a lot of time, talking here. I want to give an opportunity to answer questions.
I want to have the committee give an opportunity to address you with any questions that may have, Mr. Gall. Anyone over here have a question? Yes, sir. Mr. Tomlin.
They usually have older neighborhoods where
Right.
blight occurs. If you did away with eminent domain, would you have a tendency for cities to continue to deteriorate and then more urban sprawl?
Well, I mean, that's an argument that I hear all the time. But what happens, I think a lot of times, I mean, cities that complain of this, there's code enforcement that's available. There's lots of things you can do, to keep properties from running down. The problem that I actually see is quite the opposite, where whole areas will be designated as blighted. Because in order to designate an area as blighted, not every property has to be blighted. You can have perfectly nice areas, and you can designate an area as blighted. What you'll see a lot of times, those designations are left in place for a while, and so you'll see disinvestment in an area. It's almost like it becomes a self-fulfilling prophecy. You can have development without eminent domain, and you can have I mean that can happen. The problem is cities that become too reliant on eminent domain for development. What you see them do is engage in clear cutting of existing neighborhoods, to put up a big box store, or to put up condominiums or something like that. And it's privately driven. So I mean, the sprawl issue. I think I think when you're just kind of allowing these wholesale condemnations, I think it can actually contribute to it. In fact, I've seen nice quiet neighborhoods demolished so that you can put up something that's going to generate 5, 6, 700 times the traffic that was generated before.
Thank you. Anything else?
it's not so-called blight. There are certain areas of Atlanta that certainly do suffer under some real blight, and so we are concerned about completely stripping away. But I am concerned, obviously, from given some of the horror stories that you've told, and I'm not looking because someone doesn't have a three-car garage for someone to designate as blight. If we were to try to tighten that restriction, what kind of language do you think we should be using?
I think if you're going to go there, I mean, and once again, I would say
I know it's a fallback for you,
yeah, but also, I mean, I do want to emphasize
Yeah.
that when it comes to properties that are really dangerous, I mean, a couple things. I mean, there's code enforcement. There's also, I mean, the police power would allow like a real nuisance, like a crack house or something like that, would allow that to occur. If you're going to go to blight, once again, I would use language that really talked about the property being. I mean, it's kind of close to the police power that you have anyway,
Yeah.
which is properties that have an immediate danger or harm to the surrounding community. That's as much as I would go. I mean, if you'd like to take a look at our website, which is castlecoalition.org, we do have model language, including model. There is model blight language.
Which is going to be my next question.
That's on the website. I even think though that that the tighter that you can get that. In fact, in some of the other language says has exceptions for you're removing a harm to the immediate threat and public safety or abandoned buildings or something like that. That's what you could do.
We also have problems within the city of Atlanta. Some you mentioned multiple owners as a loophole, as you put it, for allowing for eminent domain. We do have some parcels of property throughout the city of Atlanta in which, given the long history of the city, that you can't find the owner because it's been over so many hundreds of years. And how do we deal with that situation?
I mean, if you truly cannot, I mean,
Yeah.
if you've published notices, if you've done, I mean, it requires diligence on the part, first on the part of any city to actually, define the owner. But if there is an abandoned property, that is sitting there, I mean, condemning that and selling that on, at the courthouse, steps,
Sure.
Because you can't find any owner and you've been very diligent about that. That is something that would probably be okay for you to have.
Do you have any kind of specific examples from any states where you found the statute to be sufficient in that area that we could look to?
The problem is all the urban renewal statutes
Yeah.
are pretty much, they're not exactly the same,
Sure.
but they're pretty much the same. If you want, in terms of, we're starting to see better language. What the Pennsylvania Senate just passed, SB 881, that is now headed to the House there, takes at least it tries to narrow down the definition of blight. I'm trying to remember if abandoned properties is in there or not, and I can't remember
Yeah.
that right off the top of my head. It's just we're so early in the legislative session as far as language goes. So we have our model. I'm trying to remember if Utah's language, is particularly good on this issue or not. But the key, no matter who you're using as a model, if you're going that route, is threats to
Yeah.
health and safety.
I mean, are there any states you're talking about? We'll stick on blight real quickly. Then I have a couple other real quick questions, if that's okay, Mr. Chairman. Are there any states out there who have tightened up the restrictions on the definition of blight that you would like to use sort of as a model for us?
Well, I mean, once again, we're so. I mean, the real legislative push, as you know,
Yeah.
didn't really begin until after Kelo, and most states didn't have just really come back into legislative session.
Sure.
The only states that have really been truly like active in terms of getting stuff passed are Texas, Delaware, Alabama, Pennsylvania. Senate has passed something. We expect, and they did that, before the end of the year, and they're going to do more. So Pennsylvania, of all of those, Pennsylvania probably did the best job of tightening blight. We're seeing a lot of proposals. I mean, there are a ton. I mean, in fact, if you want to go to our website, we have every single piece of legislation that's been introduced in every state that's available for you to look at. And New Hampshire, I know, has got some legislation that's coming up that's really tight. Although I think New Hampshire probably takes an approach that is more closer to what Utah has done, and frankly closer to what like the substitute for SB 86 does, which is similar to is just outright removal of authorizations.
Have you?
One more question,
I'm
Mr.
sorry.
Lindsay.
Thank you. I'll move on, but I appreciate it, Mr. Chairman. Have you looked at the issue dealing with who is actually making the? Perhaps you did touch on it when it comes to stripping the authorities of their power to condemn. One thing I've been concerned about is unelected officials having a power to condemn as opposed to elected officials.
Well, it's I mean, some states do. There are Missouri, for example, their law specifically allows private corporations to condemn. I mean, I think certainly it would be, one important reform is making sure that it's only elected officials who are doing it. But I mean, the problem is this abuse occurs with elected officials all the time, because it's once again it's a privately driven process where officials think we're doing the right thing for the community as a whole. We're trying to increase tax base. We're trying to increase jobs. I mean, what happened in Kilo? That actually did involve the city voted to delegate its eminent domain powers, but the case we're litigating before the Ohio Supreme Court right now, and others, an elected city council has voted and said, blight's 2 bedrooms, you're blighted. Goodbye.
Anybody else have a question? I've got one,
Sure.
and that is, when you see other states that have placed the ability to condemn into the hands of a governing body on blighted areas, do the courts very often sit in judgment whether or not there has been, in fact, a proper application of that rule that the legislature set down, or what happens?
Well, the problem is that courts across the country are really deferential. I mean, super deferential to determinations of blight. So there is so you go to court, when you're condemned to challenge it, but courts really, one good reform would be, that just brings me to, the burden is typically on the homeowner to prove that his home isn't blighted.
Okay.
It would be better for the burden to be on the condemning authority.
What you're saying is the courts usually say, well, if the legislature says you got the right to condemn for blight, we're not going to step in and question whether or not you're applying the appropriate standard to define that blight. Have you seen anybody use a third party as a means of a mechanism of saying, okay, the city, the county defines an area as being blighted, a project to be taken because it is blighted, and then there's a third party, independent, that will pass upon that to be sure that they have met the appropriate standards that the legislature set out defining blight. Has anybody done that?
Typically, no. I mean, typically courts are going to be so deferential to the determination of blight that is made, and because what you often see is
Not using the court. I'm talking about
unfortunately, the third party is typically, there's not a third party kind of overseeing, like, is this really blight or not? Unfortunately, there's often a third party who's very interested in making sure that the area is declared blighted, because he may be financing the study, because he's doing the development.
Okay. Any other questions? Mr. Gall, I appreciate your being with us today. Wanted to, in closing this, we were asking Mr. Gall specifically as a guest to come speak. It wasn't something we're opening up as a debate at this point in time on the questions about eminent domain or even the question of blight. We knew you were coming into town, and we wanted to invite you to come by to speak to the committee. So we're not going to have a further discussion today on the various aspects of eminent domain, but thank you for being with us.
Thank you
Appreciate your
for
time.
having me here. I appreciate it.
We'll go forward with the regular part of our hearing. I believe we've got a quorum present at this time. What we will do, I know that Ms. Lunsford's here on behalf of Senator Smith on Senate Bill 253, and we'll take that one up first. Yes, sir. I didn't want you to wait. Yes, sir. I will let, as soon as Mr. Gall is able to. Yes, sir. Thank you again for coming.
Thank you, Mr. Chairman and members of this committee, and I appreciate you taking me. I do have another place I'm supposed to be, as we all do during this time of year. Senate Bill 253, I'm carrying it for Preston Smith. And the reason being is it was myself and Mike Boggs 3 years ago that drafted the original legislation. Of course, Representative Boggs now is a judge down in South Georgia. And we had a couple little problems in it that really, I hate to use the terminology, a little bit of housekeeping. We had used the word certificate throughout the body of the bill, meaning certificate of permanent location or certificate of removal. But it became a great deal of confusion in different jurisdictions. Did that mean certificate of title, which was what we were trying to replace, was a certificate of title? So, on request of the clerks and also on the Bar Association, they asked us to spell out the word certificate of permanent location and then also the removal of the certificate of permanent location, so that we've actually spelled out the terminology of what it was. And, Mr. Chairman, I'd be happy to answer any questions, but what this actually in essence did was allowed someone that purchased a manufactured home, put it onto a piece of property and declared it as permanent property to receive the same essence as having real property instead of personal property for that home once it was permanently located on that property.
Comes affixed to the realty itself.
Yes, sir, that is correct.
And we had this bill up last year, as I recall, and it was passed out of committee, but did not get on floor through rules in time because it happened pretty much toward the end of the session, as I remember. Is that correct?
Yes, sir, that is correct.
Yes, it was.
Yes, sir, that is correct.
And it was passed out from committee with a, I think, a recommendation, correct?
Yes, sir, that is
Okay.
correct.
Yes, ma'am. You go puzzle. Go ahead.
Subpart 1A, which looks like the new substantive procedure that you're creating that's different from the previous statute.
Give me where you're
Everything
talking
else
about.
is a
I'm sorry,
typo.
1A.
Page 4,
Page 4, okay.
subpart 1A. This, everything else is a renaming except this. Is this the new, what is this?
Yeah.
Ms. Oliver, what, if you recall, since the time we originally did this legislation, we've changed that department for the state, because that used to be handled through Department of Motor Vehicle Safety, which no longer actually exists, or didn't exist. Now it exists as Motor Vehicle Safety, and we changed the name of that department. The other thing is we still had to have a mechanism that once it was affixed that we could remove it. So if they put, pardon the expression, they put some wheels under it and took it someplace else, it no longer was permanently affixed as real property at that location. And what we wanted was a certificate of permanent location that the clerk would have. We also, in this bill, created a mechanism by which a brand new manufactured home could be put out there with a lot less paperwork, stated by the manufacturer that it was manufactured as real property and going to be delivered directly to a location, and they wouldn't have to kind of go through this convoluted mess that we have here trying to create real property out of personal property. I haven't read through it verbatim, but what this language, if I recall correctly from last year, was asked for by the Bar and the Clerks Association to try to clarify it so that they would be real clear.
This doesn't come from the bar section though, does it?
It came with a recommendation, yes, ma'am. It was prepared by a section of the bar. There's been a difficult time in the past with this changeover and the grayness it was causing, where you have somebody takes a manufactured home, brings it out, places on real property, and from a taxing authority, does that become a part of the realty, or does it continue to be taxed as a, quote, personal property separate from the realty? And the difficulty's been, it's been handled in counties differently. There's always been a question about, for instance, a UCC filings. What has to go with those things, as opposed to security interest attached to the property with this fixture now becoming a part of the realty.
We're going to hear in a second whether there's any objection from any of the members of the authority.
Sure. Yes, we will.
No, ma'am. Actually, part of this subsection 1A, Mr. Chairman, if I may, clarify for the Department of Motor Vehicle Safety that they didn't still have a car title to this home, and they didn't have to respond to them any longer. It was no longer a vehicle.
And that's where that so-called certificate of permanent location comes into being as a part of the process on that. Any other questions of Representative Lunsford? All right, thank you so much for coming and presenting the bill. We're going to see if there's anyone further to speak in support of Senate Bill 253. Anyone else?
Mr. Chairman, I think the gentleman over here.
Yes, sir. Please come forward and give us your name.
My name is David Burge. I'm vice chairman, or chair-elect of the Real Property section of the State Bar, and I'm past chairman of the legislative committee. So I was involved in some of the discussions on this bill last term.
Yes, sir.
Also one of Mr. Lindsay's constituents.
Well, Mr. Burge, maybe you can help clarify. What was the question you had, Ms. Oliver?
Is this a tax shift and a management shift and a clarification of a title? That's where it seems all at once.
What we're trying to, there were a number of technical cleanup changes in the bill. The substantive change was when you're buying a new manufactured housing, it's subject to the motor vehicle statute because it's still classified a motor vehicle. And like a new car, you get a certificate of origin from the manufacturer, then you have to get your title from the motor vehicle office, and then the procedure, which is already on the books, to cancel that motor vehicle title and get the manufactured housing declared as real estate would be triggered. So you would have to get a title and then immediately cancel it. The problem has been on the mortgage lender side, because when a mortgage company advances money, they want the closing attorney to certify at closing that you have a valid mortgage that day. And the problem has been, because you have to get the motor vehicle title, then record the affidavit, then cancel the motor vehicle title, then go to the tax assessor and get that corrected, the attorney either had to say, we have to do these, had to tell the mortgage company, you'll have a mortgage but not yet, or not close the loan in accordance with the lender's terms. So this is not really changing the end result, it's streamlining the procedure that already exists. And so at the end of the day, if you take your manufactured housing, attach it to the real estate, you'll have a piece of real property that's assessed as real estate, and you'll pay property taxes on that basis. It's just the procedure for getting there is streamlined when the manufactured housing will never be moved again.
I remember historically when it was a motor vehicle license versus a real property deed. But does any of this procedure that you set out in subpart 1A change who pays the tax at any one point, or is that irrelevant question?
That does not change, because you will have, until, it will be taxed as personal property until the change is made, but by January 1, which is the effective date of the assessment, you'll actually be assessed at real property a lot faster. So there really is no change. The same procedure as is in place now will stay in place. It's just the time period will be shortened, but there should be no revenue change.
Yes, ma'am. Mr. Ms. Tumlin.
Not being built. I mean, would this circumvent that if somebody moved in and they got a 1% interest in a piece of property? Would that change the nature of it?
That would not change it at all. Whatever local laws on zoning are not affected by this
If
at
it
all.
went from being a trailer to a home, I'm curious because I'm not looking at the ordinance, but it still would be a manufactured home, but it would change the definition by becoming real property. And I'm just curious if that would fly in the face of counties that have such moratorium.
I don't think that it would. Again, there's no provision that purports to overrule zoning ordinances. This is strictly how the mortgage lien is perfected.
Yeah, but that's what wouldn't necessarily overcome it, but you change the nature of the. If it went from being a trailer home to a piece of real property, I think that changes. I'm just thinking out loud. It concerns me.
Again, I haven't read the ordinance, but most ordinances speak to the use of the property, and this is just.
I think what he's talking
Use
about
wouldn't be changing.
Yeah, some places, to follow up what you're saying, Mr. Tumlin, some places will have, you cannot, within this certain zoning category, place a manufactured home. Period.
That's right.
Now, his question is that going to circumvent this restriction of a local ordinance that says you cannot place a manufactured home there? In fact, does it not still continue to be a, quote, manufactured home? It just becomes a manufactured home affixed to the realty, or does it still have some separate identity?
The zoning ordinance would affect bringing the item onto the property, and that action of bringing it would still be governed by the same zoning ordinances either before or after this statute's passed. So I don't see how it would change that at all.
Okay. questions? Well, thank you, Mr. Berg. You were with the committee that prepared this bill, you say?
Yes, sir.
Okay, and it was with the support of what, the State Bar?
It was initially drafted by the State Bar Real Property Section, and it was supported by the entire State Bar, also the Manufactured Housing Association, the Georgia Community Bankers, and some of the larger national banks that lend on manufactured housing were involved, and they all concurred on this bill.
All right, thank you, sir. Please, Fleming.
A local zoning ordinance would define what is a manufactured mobile home.
Correct.
And this bill will not change that because it is still a manufactured mobile home when you roll it on the property.
That's right.
That's why you're saying that the local zoning is going to be protected, right?
That's right.
Okay, but once they get it there and they get the wheels out from underneath it and do this change, then it's no longer a manufactured mobile home. Are we doing that?
No, sir, it's still a manufactured home because it's still in its state mobile home doesn't have a word in it.
So
This would probably keep it pretty Fannie and Freddie deciding they were going to loan or
So at best, you may want to change your local ordinance to reflect the term certificate. What's the term? Certificate of order.
Yeah. I think it could even be argued that a violation occurs just by the bringing of that property onto the lot, we'll say.
Gotcha.
And even though you may attempt to do so, it will still, its original makeup was as a manufactured
Thank you, Mr. Chairman.
type home. Excuse me. Okay. Thank you, Mr. Berg. Anyone else wish to speak either in support of? Yes, ma'am. Please come forward and give us your name and the organization if you represent one.
I'd just like to correct a couple of things here and to clarify. I'm Charlotte Gaddis with the Georgia Manufactured Housing Association. A manufactured home is defined in federal and state law, and once it is placed on the property, it will not change. It will always continue to be a manufactured home, regardless of whether it's real or personal property. That is clarified strictly in federal and state law. This particular bill will not affect your local area's ability to zone them in or zone them out, which they do the majority of the time, as we know, but it will not affect that whatsoever. I just wanted to clarify
Great.
that.
Thank you, Ms. Gaddis. Good to see you. Anyone else wish to speak in support of the bill or in opposition to the bill? All right, it's with the committee. Do we have a motion on the bill? All right. Have a motion to pass. Any further discussion on the bill? Do we have any amendments to the bill? I've got one I want to bring to the committee's attention. If you look on page 4, line 2, we have a date that is from the last year bill. The date is July 1, 2005. I will offer amendment to change the date on line 4 to read July 1, 2006. Any discussion on the proposed amendment? All those in favor of the amendment signify by saying aye. Aye. Opposed, like sign. Go back to the main question. Any further amendments on the bill? All right, the main question is a motion do pass. All in favor of the motion as stated signify by saying aye. As amended, signify by saying aye. Aye. Opposed, like sign. You have a favorable recommendation. Thank you. I'd like to take a moment to recognize we have with us Judge Lawton Stevens from the Athens, Clark County, Eastern Circuit? Western Circuit. Eastern Savannah, excuse me. That's right. We're glad to have you with us today. He is here to visit and watch what we do and be sure we do the right thing. Nice to have you. Thank you for coming. Our next bill, we'll go back to the top, which is House Bill 494, the Notary Public Bill. And this is being presented by Mr. Lindsay. And Ms. Lindsay, you may, if you wish, keep your seat to do so.
Thank you, Mr. Chairman. administration may only use a business address for the application if the applicant is applying pursuant to a particular code section. The particular concerns that are addressed herein, Mr. Chairman, come to me from Fulton County, and I have Ms. Diane Hutchins here perhaps to address them a little bit more specifically, is being able to maintain contact between the county authority that grants the notary certification and the notary. And they've had some difficulty with maintaining contact in the past, and given the important role that notaries have in our society when it comes to certifying the signatures on vital documents, we felt that this was something that was important. If I could allow Ms. Hutchins to sort of explain a little bit further.
Sure. Good afternoon.
Good
Ms.
afternoon,
Hutchins.
Mr. Chairman, members of the committee. I'm Diane Hutchins, Executive Director of Intergovernmental Affairs for Fulton County. Those of you who are veterans of this committee may think you're having a case of deja vu, and you actually are. This bill has been before you, and the bill as it sits is what this committee passed out unanimously in the 2004 session of the Georgia General Assembly. The reason for this bill is, as Representative Lindsay has outlined, we know that for all real estate transactions in this state, notarization is required. And we also know that we have a very, very high rate of foreclosure and mortgage fraud in this state. And Fulton County, unfortunately, has the largest percentage of that large rate. We felt that when we went back and looked at the notary public law, it was important for us to do some updating, because our research shows that most of this law dates back to the days before this state was a state, when it was a colony still, and that most of this law most recently was amended in the 1930s, and that maybe it was time to bring this into the 21st century, and that a very simple way to do this was to say that endorsers of people who wish to be notaries public must know the applicant. As it stands right now, current law says that you must not be related. It doesn't say that you have to know the person. And that we also need to know how to get a hold of these people, and that they give actual and legitimate phone numbers and addresses. And we would ask that this committee, if at all possible, give this bill a due pass recommendation.
Thank you, ma'am. Any questions of Ms. Hutchins? I've got one, if I might.
Yes,
What
sir.
is the provision 4717.7, without pulling out the code, which is the exception we speak of several times in the bill? Is that the at-large?
Yes, it is. I believe it is.
Non-resident?
No residents.
Okay,
Yep,
non-resident.
that's what I thought you meant by at large. I'm
Do
sorry.
wish to see the code, Mr. Chairman, I ask
I'm
VA to.
I'm fine. Just wonder what we're
Yeah.
accepting to there. All right.
Thank you, Chair.
Yes, ma'am, Ms. Thomas. Might want to speak at that mic, because we're going to have you on television.
Oh, well, let me make sure I get everything. Just kidding. On page 2, line 24, I don't know, it says something about must know the person for at least, the person who endorsed you must know you for 1 year, just for you to get just to get the license, but not necessarily for you using the services of a notary.
That's correct.
Okay,
Just for the application process,
okay.
Representative Thomas.
okay.
Any further questions of Ms. Hutchins? Well, thank you for coming in today. Appreciate your
Thank you,
being
Mr. Chairman, members of the committee.
here. Anyone else speaking in support of the House bill? Anyone wish to speak in opposition to the bill? We'll close off the public portion of the debate on the bill. Do I have a motion on the bill? Got a motion to pass? And second to the motion? Any discussion regarding the bill? Any amendments to the bill? Committee's ready to vote. All those in favor? Call the question. All those in favor of, excuse me, I lost the number. House Bill 494 signify by saying aye.
Aye.
All those opposed, like sign. We have a due pass recommendation. Next will be House Bill 705, which is the private process service bill. We have Representative Foster. If you come forward, please, sir, and we'll let you present the bill to us, if you would.
Thank you, Mr. Chairman, members of the committee. Bring for you today HB 705, Civil Practice Process Servers. A couple of new code sections, one to authorize private process servers' interest into gated communities, and the other to permit private process servers to serve papers in any county in Georgia after they've passed the test administered by administrative courts and sworn in by the Superior Court judge. This was brought, currently I believe the process servers go to the court districts such as Lookout Mountain District, the Conasauga District, to be able to be put on a list, and it's not a statewide thing. This expands the service pretty much to statewide, and we've had discussions on this bill, and I've seen that you have made Mr. Chairman, you've made some great refinements to the bill. I'd like to applaud you on that from what we had
Louder.
before. A little louder, okay. And before we had discussions on the first section of the bill talked about when you go into a gated community, if you weren't allowed access, then the papers would be given to the person in charge of the guard, whatever, which was not a feasible thing to do. So we've taken that out. And in the second section, it was needed more clarification about the process of approval and requirements for that approval. And I'd request your favorable consideration on the House Committee Judiciary substitute to HB 705.
Any questions of Representative Foster? Yes, ma'am. Ms. Oliver?
Do you think that the AOC is gonna set a fee schedule?
No.
Or is there any this is gonna be purely,
Purely
Whatever they
contract,
wanna-
negotiated price with a private process server and for whom they may be doing the service. That's the intent of leaving it open. Any further questions, Ms. Oliver? Any other questions? Committee members? Let me follow up just to tell the committee what we were talking about, Mr. Foster. We did clarify, we wanted to be sure the process server having access to, quote, gated and secure communities applied not only to a private process server, but even to an official such as someone representing the sheriff or a marshal doing service. We're directing that they shall be permitted access to those secure communities. The other thing that we were doing with the bill, attempting to do, was the concern has been, certainly with the bar for some time, is having the opportunity for a process server to have access throughout a larger area than just a county or for one court. So we wanted to set up a procedure in here dealing with the administrative office of courts where they can go to become certified. That certification be based upon their being examined, doing a background check as a part of that examination, also having a testing done of them to be sure that they are familiar completely as a sheriff would be or a marshal would be with the requirements under the law for making service, whether it be upon individuals, whether it be upon a minor individual, whether it be upon a partnership, whether it be upon a corporation, whatever need of service, that they have the knowledge of the steps required for that. And once they have met that requirement, then they would be approved by being certified, but still would require to go before a judicial officer and take an oath. That's right. Looking for the Section D, where they would in effect be sworn in as a party to do private process serving, recognizing they cannot do it where they're related to the party for whom they're making the service or even have a financial interest.
Yes, sir.
So the idea is to be sure they are maintaining their independence and not doing something, because they may be called upon to appear in court with the need of showing the fact that they've made appropriate service. And I suggest it's been a problem in the past, because if you had a private person you want to use as a lawyer or a client for a service or process, you have to go through a somewhat cumbersome process of filing a motion, having a person approved for private process and serving and getting an order. So we're trying to streamline and put this into a more not only economical basis, but a usable, friendly basis for the attorneys, the courts, and businesses and persons that need to, from time to time, use private process service. A good example is those who own apartments a lot of times, and having unfortunately filed dispossessory warrants, and they have to go through the marshal's office, and sometimes it's difficult getting good service made. It's true if somebody's trying to avoid service. So the idea is to have somebody that's employed to help accomplish that where necessary, because I think it's not always even easy for the sheriff's office or the marshal's office to fulfill the various duties required of them in this area. So we're trying to get some assistance to, say, the bar, the public, the courts, and the sheriff and marshal's office. Yes, you got something you want to say?
Yes, sir. A couple things. I was going to say that the opposition that I've gotten from this bill has been from the Sheriff's Association, and I've tried to assure that it's not a really taking away of business from the Sheriff's Office. It's a assistance with the backlog of the process to be served. The other thing that I have is with the Georgia Private Detectives Association. If I could make a suggestion, you could take it under consideration. On page 1, line 24, where it says serving in the industry for at least 1 year, they would like to see if we could change that to 6 months. And then the other is just a clarification on page 2, section A at line 12, to somehow clarify that, to say that if there is a felony there, that we don't have felons serving process.
I think the intent is that would be something that would expose a person perhaps to the administrative office of courts as not part of their rules.
Yes, sir.
And that would be where they would implement the rules and regulations that would recognize that somebody who has a criminal record, whatever, whether it be a crime of moral turpitude, for instance, that person would not meet the qualifications. So we're going to have them come in with the criminal background check, and then let their rules be the ones that give those guidance how it be applied. Yes, ma'am, Ms. Oliver.
Your gated community provision is a real good one because it's just a special problem. I think, at the risk of, being an old fogey here, one of the consequences of passing this, in my opinion, is that you're creating a business out there that is not bonded and may or may not be subject to any real accountability under the AOC, and their prices are going to be higher than what you give to the sheriff.
Absolutely.
I don't, even in a very big, complicated county, I really generally don't have problems with service by the sheriff's office, and it's just a tradition of faith that I have that they're accountable. This has to be coming from a business interest out there that wants to do this as a business. Is that fair to state, Mr. Forrester?
Well, if the process servers group, of course, would like to see more flexibility in their ability.
I think there's already an industry out there. It's just somewhat cumbersome, the process. Some of them get approved by courts on a permanent basis. Some have to get approved every time they want to make a service or process. So that's what I'm saying. It's a little bit archaic, cumbersome way of handling it. We're looking for a way of, I say, making it user-friendly.
I'm just trying to figure out how the AOC does this in a realistic way. That's what I'm trying to figure out.
Do we have somebody here from the Administrative Office of Courts? We have Ms. As we're going to talk to you in just a minute. Mike, you bring that up and we'll get that discussed. Mr. Hatfield.
To serve people in those communities, but there's nothing written into the statute that will provide any consequences for a failure of a guard or a gatekeeper to admit a process server. In other words, there's no remedial authority there.
say that a person being authorized under this section has statewide authority. So it would have application to a jurisdiction other than the one where this person may reside or.
Okay, but I'm asking, like, for example, suppose Judge Stevens wants to appoint somebody just to serve process in the Western Circuit, can he still
He
do
can still
that?
do that. Oh, yeah.
Statute?
He can
Because
still
this
do.
is only giving us rules and
Exactly.
regulations for statewide process.
That's right. He can still do that. Correct.
I bet he'll like that. Okay.
Okay, and thank you. Anybody want to ask of Representative Foster any further questions? All right, thank you, sir. Others speaking in support of the proposed legislation, I'd like to get Ms. Nesbitt to maybe when she has a chance, I want to have you tell how this would work as far as the administrative office of the court. Please, ma'am. Judicial Council of Georgia.
Thank you, Mr. Chair. I'm Deborah Nesbitt with the Administrative Office of the Courts and the Judicial Council of Georgia. And let me say right off that the Judicial Council has not reviewed this legislation on this committee sub. We provided information to the chairman about how we thought this could work if he moved forward with legislation. And we certify court reporters and keep and maintain a registry of that as we do court reporters. And so we envision that this would work similar to that. We have several regulatory functions under our agency, like we register private probation companies and private probation officers, run criminal background checks. And so we do have the structure there to do this if this is something that the legislature decides to move forward on. There are just one or two things that I noticed as I reviewed the bill at the top of page 2, line 1, where it says rules or regulations promulgated by the AOC. It would be better if that said Judicial Council of Georgia.
All right. I'm sorry, I thought y'all did. I know we had a discussion, but you never got the follow-up bill after the changes were
No,
made?
sir, I didn't.
My apologies.
It's okay.
I thought that was to happen.
And then number 2A, line 12, that paragraph, and I'll just tell you this is personal work experience I've had. If they undergo a criminal record check at their local law enforcement agency, many times they're just checking their record for that county and not as a state or a national check. So it would be better if it says undergo a criminal background check through the Georgia Crime Information Center by the Administrative Office of the Courts. That means we're doing a GCIC check and not just a county check.
All right.
Does that make sense?
Yes, ma'am.
GCIC runs against NCIC. In other words, when we run a check through GCIC, it automatically checks the federal registry as well. Are there any other questions?
How would this work as far as procedurally? This is something you say you do with other type of groups, such as the private probation companies, court reporters, which are all outside of.
I would think that and again, I have not taken this before the full Judicial Council, but a structure that could potentially work would be that there be a committee of the Judicial Council that takes on the responsibility of the oversight of the process servers and the setting of the rules and regs. The Administrative Office of the Courts is the administrative arm of the Judicial Council, so we would do the day-to-day work.
Let me clarify something. From the last time we talked, have you been back and spoken to the Judicial Council of Georgia about this proposed process that we're setting up?
No, sir, we have not had a meeting.
You want to do that?
Now, I can do that.
Do you want to do that?
Yes, we can
You'd rather have this deferred until that's done?
I think that would probably be best.
All right.
They don't have another meeting. I'll have to do it by fax and email and do a conference call.
All right. I'd rather do that because of limited time we have. What would be a comfortable time frame for you to get this out to your Judicial Council and get feedback?
Next week?
Oh, yeah.
Okay.
A week would be
I think
sufficient.
a week would give me enough time to get that set up and get it faxed out to everybody.
All right. questions of Ms. Nesbitt, please? Anybody else? Thank you for
Thank you.
coming in.
Thank you.
I'm going to go ahead and conduct a hearing since we have people here I know about the bill. Is there anybody else who wishes to speak in support of House Bill 705? Anyone here wish to speak in opposition to House Bill 705? Yes, sir. Come forward, please, and give us your full name.
Thank you, Mr. Chairman and the committee. I'm Oliver Hunter, General Counsel for the Georgia Sheriff Association. And we have no issue or problem with Section 1 of the bill, which deals with the servicing gated communities. But that one of the questions raised by one of the members point to an issue we have with Section 2. And that is our position, quite frankly, that the service of process is essentially a law enforcement function. And what happens, for instance, if an individual goes to a gated community and the guard says, no, I'm not going to let you in, and it escalates to a violent situation, we take the position that you need to have the authority to make an arrest, or at least the apparent authority to do so. And many times what appears to be a fairly routine, run-of-the-mill service of process escalates into a violent situation. And you place people at risk who are unable to effectively address the issue at hand. And that poses a primary concern for us. Secondly, we just have not heard of individuals having a problem having service of process accomplished. And we think there, to the extent there may be a problem, there exists remedies to address that through the judges appointing process services for the county or for the circuit, or even some kinds of permanent process service. We just see, we don't understand what we're trying to fix here, I guess what I'm trying to say, Mr. Chairman. And finally, the point we'd like to make is that presently sheriffs charge $25 for service for process. We suspect that private companies won't be charging $25. And to the extent...
Or less.
Or even less, that's for sure.
I mean, they be charging more or being charging less?
I think the charge will be considerably higher
right.
by the private process services. You're not going to get this kind of service efficiently and more effective than what you have now with the sheriffs and marshals.
Right.
Again, except for the issue that's implied, it's implicit, the whole problem with it. Section 1, we have no issue with it, but we do ask you to recognize that you're putting folks in peril sometimes. And what may be a fairly routine domestic divorce or custody issue, and you think it's no big deal, you know, we think it could very well, very quickly escalate into a real big deal. And we ask you to take that into consideration as you consider this bill.
All right, hold on, Mr. Hunter. Maybe someone have questions of Mr. Hunter. Yes, sir, Mr. Tumlin.
You referred to about private being broke. A lot of times the judges appoint it's the same people over and over and over. Not that it's broke. It's a lot of times the process. You have the same person, whether it's Cobb, Clark, or whatever, it's gone through the process over and over and over. To me, that's what it's supposed to fix it sometimes. To say the repetition before the court. You know, just to say, I mean, that's just me.
Well, I appreciate your point.
Okay, anything further, Mr. Tumlin? We're on House Bill 705. Over here, we have, yes, sir, Mr. Fleming.
No, I said we don't oppose the section number 1.
No, I'm saying the current law, the law that right now allows Judge Stevens or any other judge to appoint a process server if they so choose.
Well, I didn't think the current law was at issue in terms of having opposition to it. We've taken a position on the current law. We're not here to attack the current law. We're here to try to, I think, address what's under consideration by this body.
So does that mean you have a problem with the current law or you don't have a problem with the current law?
We don't have a problem with it, but I wasn't.
Here's my point.
Okay.
Anything that could go wrong with a process server under this situation could go wrong with a process server under the current law.
To the extent, I think by and large, most service process is done by law enforcement. True enough, there exist cases where the judges
sheriff's office. So I mean, it's really a freedom of choice issue for the attorney. I mean, he might think that the private process server can get it done quicker. He needs it done quicker, and he's willing to pay a little more for it. I mean, why shouldn't we give people that choice?
You're absolutely right. You're absolutely right. My only point is the observation that the cost of litigation rises. I'm sure that cost will be passed on. I don't argue that no, she shouldn't have the right to do that. Certainly, I mean, the option ought to be that for if he wants to, but the cost of litigation obviously rises by the increased cost of service, and that's a point. I'll make that's a point of observation for you guys to consider.
The last question I would have for you is that, if anything, in my observation would be that this would lessen the workload on the sheriff's department by some extent. I know when I was chairman of the county commission, I loved my sheriff to death, but he had never had enough cars, he never had enough sheriffs, and he never had enough deputies and enough guns, and we couldn't have enough money for him ever. So I mean, if anything, although maybe a small part, wouldn't this possibly lessen the load on the sheriff's department if you had people out there being paid by the private sector to do what you would have to do with public funds otherwise?
I answer that this way, Mr. Clements, that the sheriffs of the association unanimously oppose this bill. They see this as a function that really is one that ought to be extensively reserved to law enforcement units, be it marshals themselves. So to the extent they may not gladly take officers away from other functions to do this, they recognize it as an essential function of their office.
Thank you.
Thank you.
Further questions on my left? Anybody else? Yes, sir, Mr. Hatfield.
What is the current method of disposition of funds that are paid to the sheriff's office for service process? Does the sheriff's office retain those funds?
Those funds go to the general fund of the county commission. That's correct.
And if I can follow up with that, everything I've seen study-wise dealing with the cost of making service by sheriffs or marshals, the amount we have as far as statutory fees does not cover that cost. Isn't that true?
That's correct.
Thank you. And anything else? I notice you're from Stockbridge, Georgia.
That's where our office is.
We've had some discussions about Stockbridge recently.
All pleasant, I hope.
At times it wasn't. Has to do with our new city hall they're building us in there. I just digress for a moment. Anyone else wish to speak either in opposition or comments about the bill? If you'd like to step forward. Yes, sir. I'll let you come forward and have a seat where Mr. Hunter's been. Thank you.
Thank you.
Thank you, Mr. Hunter. Appreciate your taking the time to come be with us. Can you state your name and with who you're representing?
Chairman Willard, members of the committee, thank you for allowing me to address you. My name is Paul Tammeroff.
Yes, sir. And who do you represent,
I'm
Mr. Tamroff?
representing the Georgia Association of Professional Process Servers as past president, along with
Have,
present president.
please have a seat.
Here's past president of the association, as well as being a licensed investigator with a licensed investigative agency. I'm also an active member of the Georgia Bar. That's not to say that I'm speaking for the Bar Association or for the private investigators throughout the state, but I can speak from the perspective of all 3 points of view. specifically certain measures raised by Mr. Hunter. With regard to private process servers would probably charge more than sheriffs and marshals, I can assure you that we will, because it costs more than $25 to serve process.
Always charging me more, I know that.
And we're not in business to go out of business. But on the other side of that equation, when we charge $50 or more to serve a paper, the parties are paying for it and not the county. So, and the parties can also put in after the case is over to get their costs back for serving those papers. So we think that's a good thing. As far as the possible violence, I personally do not see any more violence coming up as a result of this bill, the gated community section, than we've had in the past. Certainly there have been occasions when there has been some violence. Since I've been in business since 1983, I had one occasion. I know one of my process servers has had an occasion. It's going to happen. But we believe that with the requirements that are being put into effect, our process servers are going to have to be educated on the law through all the process servers throughout the state. They're going to have to know what they can do and what they can't do. We presume that there will be questions raised by the test and by continuing education that would be required as a result of having to be tested as to what you do in these types of situations. So we don't really see that there's going to be a problem. We think that the bill itself is going to solve some of the problems we've had in the past. With that, I really don't want to go any further because I do feel that the bill has been fully covered.
Let me respond to the first thing several people talked about as far as Section 1. I weighed whether or not something should be put in here trying to find sanctions. My belief is that once people are made aware of what the law directs them to do, they do it voluntarily at that point. The idea being that the law says the guards, whoever there, shall, which is directive, allow a process server, whoever it may be, whether it's a sheriff or a marshal or a private process server, on the premises to do what is a charged duty that person has. So that's my thinking is if the private process server goes out or a marshal goes out and they get to a situation like that, say, well, here's what the law says. You're supposed to allow me to go on the premises in order to make my service. I think people will comply. If we find they don't, then we'll have to drop back and re-examine that point. But I think not trying to place sanctions there, but just give directive to all persons that there is an obligation under the law to let service process occur as is required by law. Simple as that. Yes, sir, Mr. Bruce. You might want to turn your mic on if it's not on.
Another committee meeting. But I was aware of this bill and I wanted to get back over here. Do you guys wear any kind of a uniform, or how does somebody know that you are a processor before you get to the door, so to speak?
Well, that's the benefit of being a private process server. In many instances, we find that the marshal or the deputy sheriff has been unable to serve process because for people that are evading service, when they see a uniform coming up the walk, they're not going to answer the door. And we get these papers, and where the marshal couldn't serve it, we have been able to serve the papers.
Mr. Chairman, I'm going to say this,
Please.
and I'm not trying to be funny, but I'm real concerned. There was another bill that they were talking about that would allow people to basically shoot folks that they thought were threatening them. I'm just, off there, not at the front door. If they feel threatened, that they could shoot them, and then there wouldn't be any prosecution for that person. And I'm just thinking about these guys going up to the door without, this person being forewarned, thinking they were being threatened.
Well, I would only say this, Representative Bruce. I think there have been many more law enforcement personnel shot at than private process servers.
Thank you, sir. Any other questions of Mr. Tamaroff? Thank you for coming in today, sir.
Thank you, sir.
Anyone else wish to speak either in support of or in opposition to the bill? Are you here for that purpose? Please come forward. And give us your name and who you represent.
Good afternoon. My name is Robin Martinelli, Martinelli Investigations, and I appreciate the opportunity to be able to speak to the committee. I'd first like to, if you've noticed, I am a female, and when I do go knock on the door, I have not had but maybe one incident in 10 years of violence at all. Matter of fact, my 18-year-old daughter is one of the first permanently appointed process servers and private investigators in the state of Georgia, and we pose no threat when we come to the door. Secondly, my company really does not compete with the sheriffs at all. My company competes with the national associations and the Georgia associations for people that need service of process done that day. And secondly, my husband's been with Gwinnett County Police Department over 25 years, and he's never had to serve service of process once. He's out on the road constantly. So I know that there is a section, there is a provision of Mr. Fleming had announced that, yes, you know, there is a choice, and that's what we want to give the legal community, is a choice. As you know, Rockdale County serves papers different than DeKalb County serves papers. So I'd like the opportunity for everybody to know, and part of the Georgia Association and former secretary of the National Association, that we would like to give the legal community, the attorneys, and pro se litigants the opportunity of choice between who they'd like to serve service of process. And I do serve Snellville, Georgia at $20. I really do, because that's where we live, and I do serve Snellville for $20.
Thank you, ma'am. Any questions of Ms. Martinelli? Appreciate your coming before us. Anyone else wish to speak either in support of or in opposition of House Bill 705? We've had comments that recognize we're wanting to probably hold the bill with the committee's preference at this point to have the bill held. Did you want to speak, sir? I couldn't see you. I'm sorry. I couldn't see you behind that large pole we have in the middle room. Come up, please, sir, and give us your name and who you represent.
I'm Captain Larry Lindsay with the Fulton County Sheriff's Office, and I'm speaking up against the bill. Being a service deputy, serving papers out in the field, I've had to go out on different occasions to assist process servers who have went into a gated area, whereas they had gotten into a confrontation with the security personnel at the location. And upon arriving on the scene there, the person said the process server was trying to demand their way onto the property there, and they got into into a fist altercation, which I placed an arrest the process server. Reason why? Because he had went beyond he had did something beyond what proper cause for us attacking the security officer who was doing his job. And serving the papers out here, the uniform represents law and order by the marshal and the sheriff's office. When we go to the location there to serve these papers, when the person does not allows there's a law on the books already that says that if a person stops us and performs our duty, they could be arrested. Most of the time we don't have to quote that to the people. Having went to several difficult papers myself to serve, a person born in service, once we get to the location there and we identify ourselves and we make a due diligence there, there's a section on the paper that allows us to serve the paper, leave the paper with the person there, even though they had been served. There have been some that go on travels of service to know why I did what I did in the paper of stand up in court.
Yes.
So we see it as if a process server go out there with the bill as it is now and get into an altercation, we're going to have to be some of that location there. We see the possibility of the altercation, accelerating to more than what it is then, creating the law enforcement off the body to respond to more and more of these kind of calls. Hopefully it never happened. I'm glad people have not been hurt, but it has happened. And I know for firsthand as a officer out in the field, I have personally experienced this myself. So having said that right there with the provision that the Georgia Self Association asked for, I would ask that you all look at that.
Thank you, Captain Lindsay. I appreciate the work you do to the Sheriff's Office. Is there any questions of Captain Lindsay by anyone? Thank you for appearing. And I'm sorry I didn't see you behind the pole. If I missed anyone else, please make yourselves known. If not, I want to suggest at this point, does the committee wish to go into discussion this time or wait until we get some response from the Administrative Office of Courts? I think the feeling is let's go ahead and wait, then we'll do that. I will table the bill for further discussion this time, and we'll wait to get response. We can, Ms. Nesbitt, from your counsel and specifically the judges, council of Georgia, judicial council, excuse me, of Georgia. Yes, sir. Ms. Hatfield.
I've just been sort of messing around with this section 1, but I would propose, again, as some sort of enforcement mechanism, that we perhaps add some language to the effect that any person who knowingly refuses to grant access to a gated or secure community by a person authorized under further process as mentioned in the paragraph shall be guilty of a misdemeanor.
All right.
And that would provide some
Teeth to it.
teeth to it.
Let's hold that, and we'll give that as part of the discussion we get into at the appropriate time for considering amendments to the bill. We'll go ahead and table it this time, then, to be called up by the chair at a future time.
Thank you, Mr. Chairman.
Thank you, too. Next we have is House Bill 716, which is also being presented by Representative Lindsay. We've got a substitute that's handed out.
Yes.
We'll be working off of LC 292133S. Mr. Lindsay.
Thank you, Mr. Chairman. This is a bill that's brought by myself and you and Representative Hatfield with a steady stream of lawyers coming to me over the last few days asking or offering their input into this piece of litigation to simply bring the statute up to date regarding recognition of some of the duties that legislative lawyers are facing, particularly given the rapidly dropping number of lawyers who are able to enter the General Assembly. I think this bill is very important to be able to allow lawyers to balance their duties to their clients with their duties to the courts. We essentially, Mr. Chairman, are expanding two code sections, 910-150 and 17-826, dealing with civil and criminal cases for lawyers' duties when they are appearing as lead counsel in those cases, to extend the stay that is already granted to both members of the General Assembly and also members of the staff of various legislative committees and the Speaker of the House and the President Pro Tem. Those provisions already being in the statute. Essentially what we want to do is extend the continuance and stay already recognized for the general and special sessions to also apply to legislative committees and also to apply to any other duties in which any other situations in which the member of the General Assembly or the staff are involved in official business. We have placed some certification requirements regarding that last category because it is rather broad. We want that particular individual to have to tell the court exactly what those duties are so the court can ascertain that this is a legitimate request for a stay or a continuance. That's the language contained at lines 14 and 15 in particular on page 2. Wanted to have specific language in there. I would also remind the committee members that there is a duty of candor to the court, and there are certain concerns that that attorneys who would abuse this would have certain sanctions rather than they would face if the court is able to abuse this. But I do think that this bill overall fits within the modern need or the needs of a legislative body. Yes.
All right, sir. We have a question of Mr. Lindsay by Ms. Oliver.
I am self-conscious about expanding privileges for myself. I think we all are. And we all do this juggle every day. But with the benefit of history around this code section, there have been some attempted abuses by past members of the General Assembly. That's not reflected well. It looks to me like you're expanding the privilege in a couple of specific ways. One is that you're just making consistent about staffs.
Yeah.
I wasn't aware that staffs statute, I've never read it, correct me if I'm wrong, because y'all probably know this better, but I've never understood under the statute that a judge had the discretion to tell me to come, even if it was a, if the committee meeting was a golf tournament somewhere, I'm just giving an example of a potential abuse, the judge does not have discretion to tell me that's not a good continuance. So this specification still doesn't give the judge any discretion, it just gives the member of the General Assembly an opportunity to say that my meeting with the PTA is more important than your court appearance. And if he or she wants to live with that public statement, you're granting he or she that privilege.
I believe that individual still going to have to face that judge and face this community for the abuse of that privilege. You're right. To a certain degree, it is requiring that the legislator act responsibly or face the consequences before either that court or his community for abusing it.
You're in court even more than I am.
Yeah.
And the tensions around scheduling, and the tensions around the court already believing I don't mean I as a member of the General Assembly, but I as a lawyer, are abusing the conflict statements there's just a lot of tension around not showing up for court.
Well, I found, quite frankly, there's also a great amount of pressure for me to waive certain privileges that I am already entitled to, and I generally do.
And I generally do too.
Because it's in the best interest of my clients to do so. To give you an example, during the special session last September under the existing law, I could have asked for a 3-week stay, extending beyond the session itself, which would have wiped out a specially set trial that was supposed to be conducted the following week. It was not in my client's best interest that I do so, and given the workload, quite frankly, of that special session, I sat during the General Assembly reading depositions that entitled me. So you're quite right that this provision does require us to act like responsible office holders and maintain a level of candor back and forth with the courts in order to lessen that tension.
And since you and I go to church together, I'm not worried about you abusing it, I'm not worried about me abusing it, but I am worried about, because I've seen this abused, and I'm concerned about the image that you're asking me to vote to extend a privilege for myself that I've already seen abused.
Well, I'm also asking you to extend a privilege that I think is vitally important for a lawyer operating as a legislative lawyer in the General Assembly in order to be able to continue to serve in both functions, which I feel is increasingly pressure on both sides.
I'll just say one more word, Mr.
Sure.
Chairman, if I may, and then I'll hush.
No need. Don't need.
I get all kinds of benefits being a member of the General Assembly, but one of them is not salary. Staffs get salary to be members of staff. And I don't know why we're granting extended privileges to them.
Well, essentially what we're doing is we're continuing those same privileges that have already been put in place in previous years. I would also like to add, Mr. Chairman, that Judge Lawton Stevens is here, who has served both as a judge and as a legislator, and he and I have discussed the merits of this bill, and he might have some added wisdom for the members.
You want to wait? Hold on, Judge. I'm going to let Mr. Fleming, you had a question you wanted to first talk about, bring up?
I think that your perception and understanding of this would be a little different if it took you 5 hours round trip to get up here to Atlanta for your duties. This really is a metro rural difference right here. And Representative Hatfield, who takes an 8-hour round trip, it really is harder on us that are farther away to have to deal with this issue than those of you who are right here in the metro area. And if the traffic time is right, you can be here in 30 minutes and be back. For us, it's a much different thing. The other thing I would interject into our conversation is I see this much more as our responsibility as a separation of powers issues. We are in the unique position of being members of the legislative branch, but having a responsibility, unlike most other members do, to the judicial branch of government. And those two automatically create conflicts. As far as things beyond just a session, I can give you, I'll go ahead and say 2 examples. I might could have gotten out of one, but I had 2 examples where I was appointed by the governor to serve on an oversight committee system that we created. I had 2 meetings I couldn't make it to simply because I couldn't get out of a required appearance. And had we been in session, I would have, and it wouldn't have been any problem. So there are many times outside the session itself that we are required to be places that I could not carry out my duties as a legislator because of my responsibilities to the judicial branch. Now, as far as abusing this, I guarantee you somebody has abused it in the past and somebody will abuse it in the future. That will not happen. But that does not change the fact that those of us who do not abuse it, and the fact that we're trying to encourage more attorneys to get involved in the process, that we have to split somehow our responsibilities to those 2 branches of government, one in which we serve and the other which we're subservient to.
Thank you, sir. Mr. Hatfield.
I'd just like to sort of piggyback off what Representative Fleming said there, that a couple of other responsibilities we have is responsibilities to the people who elected us to be at various meetings, events that any other state representative would be present for. And we also have the responsibility of clients as well. And I would hope, and probably what's been said is correct, that there are probably going to be abuses under any system, but I would hope that as lawyers we would always be, our judgment about using this authority would be tempered by remembering what the best interests of our clients are. So there might be situations where we would like to use that authority, but if we're thinking about the best interests of our clients, which we should, then I think that we'll hopefully exercise some good discretion.
Mr. Bruce.
Mr. Chairman, as one of 2 members of this committee that are not attorneys, I guess the question that comes to mind for me is every one of us voluntarily runs for office, and every one of us has other duties and responsibilities. I'm Vice President of Human Resources, and I get called for meetings all the time. I get called to go, sometimes go to court just like you guys do. And to afford this privilege to just lawyers, to be able to get out of their normal everyday work because they're in the legislature, and the rest of us who are also employed elsewhere and doing other things are not given that same privilege. It seems to me that there's something unfair about that.
I think you are given the privilege by law.
No, we have to make a choice. We do. We have to make a choice whether we go to that meeting or we come here.
You are required by the judicial branch, as we are, to be somewhere at a certain place in time. You have the same privileges as we do during the session, that you can't be there because you're a member of the General Assembly. That law already exists. It's in place right now. And the big difference between me and you is that I have to deal with private entities wanting me places all the time too. But the difference is another branch of government requiring me to be somewhere. That doesn't happen to you. The only branch of government that can require you to be somewhere unless you're subpoenaed in a case is the legislative branch because of your duties here. We have to compete with 2 branches of government with equal authority, one requiring us to be somewhere, and also at the time when the legislative branch requires us to do something different.
Okay, during the session, I agreed. But in the off season, when we're not in session, and I'll give you an example. I was called for jury duty, and the judge told me I had to be there. And there were committee meetings, things like that going off that were taking place. And the judge was very clear. You got to be here for jury duty or you're going to be in trouble. And so all I'm saying is that it sounds like there's a privilege being given to a particular, profession that's not available to others. And I'm not knocking you guys. I mean, I know you got to do it, but I'm just saying that is something that I would question as to why one profession would get this privilege and other professions didn't.
Well, we've got the benefit of a individual who's got the insight from both perspectives as a legislator, as a judge. And Judge Stevens, if you would please come up and give us your comments and thoughts about this proposed legislation, House Bill 716.
Thank you, Mr. Chairman. When I was in the legislature and had the privilege of serving on this committee, I used to get some of my best clients right before the legislative session because they knew if they hired me, I could get them a continuous for 3 months, and then I'd get back and they'd hire somebody else. But
got a good
that's
retainer.
Why I decided to become a judge. But I don't think any Assembly say, "Oh, I can't come to court because I've got, I'm in session or I got something else." But I think most judges recognize that a lot of the work is done in committees. It's not all done during the session. And I just think, when an attorney has a duty of candor to the tribunal, and I don't think any member of the General Assembly would abuse that. So I wouldn't have any objection to it. I don't know of any judge that would have any reasonable objection to it either.
Thank you very much. Any questions of Judge Stevens? Ma'am? No? Excuse me. Thank you for your coming forward and your candor. There was something you wanted to ask,
Yeah.
I think, Mr.
No, just want to add back to Representative
Okay.
Bruce and your point that part of this bill is designed to, quite frankly, help you in that situation, dealing with when you are required to attend court, even in a jury situation. And I got actually called to jury duty twice during the off season this year. So, and in both those situations, I did not have official duties, and I attended that jury duty. This bill is designed not just for the lawyers, but for any member of the General Assembly, dealing with the judiciary, where you have an obligation to attend something with the judiciary. It does provide you with a stay or continuance.
Let me follow up with that. Is not the current law also able to be an excuse for not being able to attend as a juror, a pettit juror to a trial, except for federal court? I think it is. I think you can use that as your legal excuse if you're in the legislature, in session anyway. In session, that's the point.
In session,
that's the boundaries.
Yeah.
But not outside of session.
Right. And this, but from my understanding of listening to this will allow for
Committees.
Outside of the session.
Could use. Yes, ma'am.
It's disingenuous to offer an amendment to something that I'm gonna vote against, and I'm gonna vote against this, but do you really think it's good policy to allow a lawyer member of the General Assembly, and I may be, tell me if I'm misreading this, a lawyer member, not a non-lawyer member, to say, I have legislative business if there's no scheduled hearing, and therefore I can't come to court? Does this bill allow me to say I have legislative business when there's no committee hearing?
Well, as enumerated by Representative Fleming, there are a lot of official duties that don't necessarily fit within the narrow
But it's
parameters
not
of a committee hearing.
in any kind of appointed thing, is it?
No, that's why I'm requiring a specific certification as to the grounds. That's why I have that added language in
If
there.
I were trying to make this better, rather than I'm just telling you what it is, so I'm sorry to appeal to you.
Can I call for the vote on the amendment?
I would certainly narrow this so it's not, that I can't, I'm gonna tell this opposing lawyer, basically, who you're messing with, I'm not coming to court because I've got a PTA meeting that's really important to make this decision. The judge doesn't care, the client may think it's good or bad depending on the client's position. It's really messing with the process of the case.
Any further discussion on the bill among the committee? Do we have a motion?
Second.
Motion to pass, seconded. Any further discussion regarding the bill? Do we have any amendments to propose for the bill? Committee members ready to vote? All those in favor of passage signify by saying aye.
Aye.
Opposed, like sign.
No.
We'll have a show of hands. All those in favor of passage of the bill, the chair is in doubt, signify by raising your right hand. Or supporting, all those opposed signify. And I vote to break the tie, and I vote in favor of passage. Any further discussion? We have next House Bill 989, the Clerks of Superior Court sunset dates, presented by Minority Leader Fleming. Majority Leader, excuse me.
Thank you, Mr. Chairman. I appreciate that.
Oh, habits are hard to break, son.
Members of the committee, I bring to you today House Bill 989, which I think is much more simple than some of the ones we previously discussed. Back in the early 90s, this legislature empowered the Superior Court Clerks Cooperative Authority to create a statewide database for UCC filings. That allowed basically anyone in a county to see a UCC filing in any other county. success of that early project became evident in the mid-90s when we also, as a legislative body, implemented the creation through the same Clerks Cooperative Authority, a statewide real estate index. The database went live in 1999, and it currently has over 20 million images online. The Clerks Cooperative Authority is also working to go backwards with all the records they have online, so even more records prior to when they went live in 99 will be available to our citizens and the people who use those databases. Going to take it all the way back to 95. All of this was made available because of a fee that was allowed by the legislature, paid by those using the clerk's system. And what this bill does is that fee had a sunset on it. It still will have a sunset on it after this bill. It simply takes it from 2010 out to 2012. That's a $5 fee on the UCC and a real estate filing. It doesn't raise the current amount. It keeps it the same, just moves out the sunset date. This bill is an agreement amongst all the parties involved, the State Bar, the Georgia Association of Realtors, and the Superior Court Clerks Authority, those who administer it, those who pay it, and the lawyers involved who use it. I think extending the sunset period out, which we do periodically, moving it out a little further this time will allow for a little more planning and security on the part of those using the system, administrating the system, to know that it'll be around for at least that long as they make the plans to expand the system. So basically, that's all the bill does, Mr. Chairman. I'd be happy to try to answer any questions.
Any questions from committee members? Let me ask a question, Mr. Fleming. How much is the fee that is
$5.
$5 for recordings of the deeds, correct?
That's correct.
Is there any reason, I'm curious, is there a reason why we have a sunset provision to it at all, or is that something that
Mike Holloman is here with the clerks
okay.
authority as their representative, and he might could answer that. I think it's to make sure that they do a good job, and that the real estate interest always wanted to make sure that if anything ever went wrong, we periodically would have to address it. I believe the Real Estate Association has been very pleased with the way the system has worked, and that's why they've agreed to allow this sunset to be moved out by 2 years.
Come on up, Mr. Holman. Talk to us about it.
I am Mike Holloman. I do represent the Superior Court Clerks. I have also with me today Ms. Cindy Mason, who is the elected Superior Court Clerk in Columbia County and a member of the Board of Directors of the Authority, and Mr. David Williams, who's hiding behind the pole, Mr. Chairman, who is the Executive Director of the Authority. Representative Fleming has exactly stated the reason that we have continually inched out the sunset. We certainly would like to do that, but we are not going to ask you that because of a negotiation a few years back between the real property section of the bar and the Georgia Association of Realtors, who in fact, for exactly the reasons that Mr. Fleming enumerated, feel more comfortable with a periodic review, if you will, or at least a periodic opportunity for them to weigh in on whether they feel like the system is giving them value for their investment in this $5 fee. And they are very happy with the system and are here, if needed, to endorse this extension. And that's exactly it. We do appreciate doing that. Keeps me employed, having to do it every 2 years too.
Keep coming back to it.
Just keep coming back.
All right. Why would we do 4 years? Any questions of Mr. Holloman? Thank you, sir.
Thank you very much.
Does anybody on the committee wish to ask the members of the Superior Court Clerks Authority? Yes, sir.
Mr. Chairman, Mr. Fleming mentioned 20 million images online. There are actually over 200 million real estate documents available on the system live 24/7.
I'd lose them too. Get that big. Any other questions you want to ask the people of the Superior Court Clerks Council? Thank you. Any discussion among the committee? Do I have a motion? Move to pass. Second. And do we have any further discussion on the proposal, the bill? All those in favor of passage of House Bill 989 signify by saying aye. Aye. Those opposed, like sign. Thank you. Any further business come before the committee? Yes, sir. Hold on. Yes, ma'am. Excuse me. Would you come come forward so we can hear you easier. It's a little bit of problem from the back of the room. And give us your name again.
My name is Mary Jane Stevens.
Yes, ma'am, Ms.
And I'm
Stevens.
from Camden County. And I came here today to bring to you a packet that I had promised my brother Melvin that I would bring to this committee. And he was to be here with me today. However, because of him not being able to come as a result of him being deceased. But we came up earlier this year also to see the committee, but the committee was not in session. And what I really wanted to do was to bring your attention to some of the problems that we incur in going before judges. And I have the packet here. Melvin was a Vietnam veteran. He had the Agent Orange cancer, and it really took a toll on him. But he was a very faithful young man. He had a problem that came up as a result of a paternal suit. However, we are a very close-knit family, and anything as far as a issue from him, we would have taken care of. But the problem came as a result of the judicial system not taking a look at what should be done.
Would you like to meet with me?
I certainly would,
and be happy to do it.
Yes, sir, and I realize that you are, but I'm here on a hope and a prayer, as they said in the appellate quote this morning.
Okay.
And there are several items I would like for you to look at and review, because there are many things that would come to you because people don't have the avenue of getting it to you.
Right.
And I know that it would come to you as far as being not taken into consideration as to what's going on with them in the court system. And I really thank you.
While you're up here, you're welcome to meet with me and any other member who would like to sit in on it after we adjourn the session, if that's all right with you.
That's fine. I have a long